This tutorial will cover the topic of ethical practice in real estate. What are ethics? Ethics is defined as the moral principles that govern a person's behaviour or the conducting of an activity. Very simply put, do to others as you would like them to do to you. At its core, the application of ethics to real estate is to exercise those moral principles in day-to-day activities that you complete in real estate on a day-to-day basis. Let's now look at some examples of ethical practice. Maintaining and developing industry qualifications, licenses, and competency and currency. A real estate agent must hold the required qualification and apply for the relevant class of registration or license. Real estate agents must renew their licenses according to state law. There are also continuing professional development requirements that must be met. Maintaining knowledge of relevant legislation and truly demonstrating this knowledge in real estate activities and transactions. Keeping up to date with legislation is vital to ensure that the agency does not put the consumer or themselves at risk. Having procedures such as having legislation as an agenda item at the weekly team meeting can ensure that legislative knowledge remains current at all times. Complying with fiduciary duty and obligations. As a skilled and influential professional, you have fiduciary duty to your client. This means that you're in a position of trust and must ensure that you and the agency put the client's interests before your own. You must not put yourself, or the agency must not put themselves in a position of profit or personal gain, or place yourselves in a position of conflict in relation to your duties and those of the interest of the principal. Let's now look at a scenario that explains this further. Let's say that you are a salesperson and you've been marketing a property that you've listed for sale, and you've obtained a contract from a prospective buyer to purchase the property, and you have obtained a price of $450,000 for that property. That means that you will make an amount of about $7,425 in commission. And this is dependent on your split that is paid by the agency when you are a commission-only agent. But you've also got a scenario where you've got another salesperson in the office that has also showed your property to a buyer that they've been working with, and they have obtained a contract to purchase the property as well. And they have obtained a contract at a price of $460,000. This means you will now have to share the commission paid by the client, and so you will then earn approximately $4,554 in commission. What should you do? You have been appointed by the client to get them the highest price. And that means that if the contract that your colleague negotiated achieves this, then you are obligated to put this offer before the client, despite it not being in your best interest. You must always put the client's interests above your own. Acting with honesty, fairness, and professionalism. This is fairly self-explanatory. Be honest. For example, if you think that the client's property is worth a certain amount in the current market, tell them the truth. Telling them what you think they want to hear will only be detrimental to your agent-principal relationship down the track. Be fair. If you have not met the client's expectations, take responsibility and be fair in your resolution. And be professional. So dress for success. Be confident, not cocky. Do what you say you're going to do. Be an expert in your field. Behave morally and ethically. Maintain your poise. Have good phone etiquette. Strike the right tone. Be structured and organized. Own up to mistakes. Exercise skill, care, and diligence. Whatever activity you are undertaking on behalf of your client, it is important to be skillful, take reasonable care, and be diligent in your approach. For example, when you are conducting an appraisal on a property, you ensure that it is based on evidence that can be substantiated, advising your client to seek legal advice on matters outside of your expertise. These all cover the topic of exercising skill, care, and diligence. Obtaining and acting according to client authority and instructions, as well as following principal instructions unless it's unlawful. Let's imagine that you have a contract from two buyers for the purchase of a client's property and you present them both to the client. They can instruct you, as the agent, which contract they would like to accept and sign. There is no breach of any laws, so you could go right ahead and act on the instruction of the principal. However, let's now take a case of a property that you are managing on behalf of a principal and the principal refuses to comply with smoke alarm laws. Simply following these instructions would put the agency at risk. Given that you have a contractual relationship with the principal, you cannot take the responsibility off your shoulders and put it on the principal. Following the unlawful instruction could result in the agency facing disciplinary action because we're expected to have the knowledge of legislation and its application over and above our clients and customers. Maintaining confidentiality and security of information. During the course of day-to-day activity, we collect various personal information from clients and customers. Apart from personal details such as names, phone numbers, and addresses, we also learn that our clients are having to sell their property due to negative circumstances such as divorce or bankruptcy. It would be very unethical to advertise the property with a headline of "Divorce pending, grab yourself a bargain." This would send the wrong message to prospective buyers and would be unlikely to meet the objective of securing the highest price for your principal. Also, you need to consider storage of sensitive information, which has to be in line with privacy laws as well as be ethical. So, looking at putting locks on filing cabinets and password protection on electronic databases and files. Maintaining independence and disclosing and managing potential conflicts of interest. As we've already learned, we are appointed by the vendor to sell their property. They are our client. We liaise with buyers to negotiate a sale. However, we must remain independent from that buyer. That is, not work in the buyer's best interest to sell the property for a lower price in their favour. If a buyer wants to appoint you to secure them a property, they can do this. This is known as a buyer's agent. This would mean that the interest of your client would then be to find the buyer a property that meets their needs and for the best, generally lowest price. But we cannot be appointed by both the buyer and seller for the same transaction. We can only receive payment from one client. Disclosure of material particulars or material facts. A material fact is a fact that, if known by the buyer, may have changed their decision to purchase the property. A highly publicised case of material fact is agents fined for failing to mention Gonzalez murders. The house where Gonzalez brutally murdered his family was placed for sale in North Ryde. The agent made no mention that the murders had occurred. So, unbeknown to the buyers, they put down an $80,000 deposit to purchase the property. Upon the sale going unconditional, the newspapers had publicised that the murder house had sold. After finding this out, the buyers refused to live at the property and wanted to terminate the contract, which the agent initially refused. It was ruled that the information would have changed the decision of the buyer and therefore the information should have been disclosed, and so the agents were fined and had to compensate the buyers due to the negative publicity. It was also stated in the case that it's not just a matter of what you say, but also what you don't say that is important. Another disclosure is beneficial interests. Circumstances where you, the agent, may be wanting to sell the property to a friend, family member, or associate is known as a beneficial interest. The client must be informed in a prescribed format under the legislation before a contract is entered into, and also a disclosure of commission and rebates. There are times when we may refer the client to a third party, for example, referral of a landlord to an insurance company for landlord insurance. If the agent or agency stands to benefit from this insurance company paying a referral fee, a rebate, or a commission for this referral, this must be disclosed to the client so they can make an informed decision as to whether they want to use the company or not. Make sure advertising and communications are not false or misleading. To reduce the chances of misleading consumers, you must take care to disclose all information relevant to the price of the property. Advertise the selling price based on a reasonable market appraisal or the price the seller has indicated they are likely to accept. Not make false claims about the price of the property. Not advertise or underquote a property at a price significantly less than the selling price to attract interest in the property. Not make false claims about the location, characteristics, or use that can be made of the land. Use clear communication in all dealings with all parties to real estate transaction, including providing written documents and signed documents. Ensure you cross your T's and dot your I's. Anything important that has been communicated via telephone conversations should be followed up in writing, at least by email, so that there is a paper trail. Any changes to contract must be in writing, and documents that are signed need to be provided to parties. For example, copy of an agency agreement is given to the client. If you don't do this, you have not executed the contract, and the contract is null and void. This concludes our session on ethical practice in real estate.